Did the IRS just lose its power? Hey everyone, Adam Bergman here, a tax attorney and founder of IRA Financial. On today's Adam Talks, it's an emergency episode. Why? Big case just dropped. Supreme Court ruling, Loper Bright Enterprises v. Raimondo, and the related case, Relentless Inc. versus Department of Commerce. And what these cases did is they overturned 40-year doctrine of Chevron. And Chevron's a very important case. It's been cited over 18,000 times by courts. And the main premise of Chevron was to defer to administrative bodies like the IRS. So when courts were interpreting administrative rules, regulations, and laws, they would essentially defer to what the administrative agency wrote and basically said, well, they're the experts, so we should defer to them. We're not going to make the opinion. If this is what they say, we will essentially treat it as the gospel. And what the Loper case is basically saying is the following, and I think Chief Justice John Roberts, who wrote for the majority in a 6-3 ruling, and this case came out end of June 2024. So I just wanted to report on it. That's why I'm kind of doing this. I'm not in the office. I'm actually away for the 4th of July weekend. And I said, I got to get this on record. It's a super important case because it could really disrupt how the IRS operates. And what I mean by the IRS operates, because it's going to impact how courts look at IRS interpretation of rules and regulations and laws. And it could empower you and me, and it also could force the IRS into more litigation and to be a little bit more cautious in what they're pursuing. So I just want to briefly discuss the case. I think the quote by Justice John Roberts kind of summarizes the majority's opinion in the case and their ruling and belief on Chevron. And this is what they wrote. Roberts wrote, Chevron defies the command of the Administrative Procedures Act, or the APA. Perhaps more fundamentally, Chevron's presumption that courts should defer to federal agencies' interpretations of ambiguous laws is misguided because agencies have no special competence in resolving statutory ambiguities, and courts do. So he's basically saying, hey, if there is a matter of law, there's an ambiguous rule, regulation, let's not just listen to the bureaucrats and the people that work in these administrative bodies. We have to interpret them, and let's make sure that the people that are elected are the ones that are actually making the rules and laws, right? Congress or government, not bureaucrats in the administrative body, lifelong bureaucrats that have worked at a government agency for 10, 15, 30 years and are interpreting rules the way they see fit. So it's a very interesting case. I actually like it. Chevron's been frustrating to a lot of people because it's basically a way for courts to just punt and say, well, we really don't understand this rule and we don't really want to deal with it. So, well, if this administrative government body says that this is the way we should interpret it, well, we're just going to listen to it because we don't want to deal with it. And that's why they cited the case, 18,000 times. So Justin Kagan wrote for the dissent. She had a different opinion. She wrote, in one fell swoop, the majority today gives itself exclusive power over every open issue, no matter how expertise-driven or policy-laden, involving the meaning of regulatory law. The implication of this decision is super far-reaching, and it will impact the IRS, as I stated. So you have these two positions from Roberts and Kagan. Roberts is basically saying we have to decide and interpret these rules. We can't just listen to the administrative bodies. And then Kagan's like, if all this open law out there, and you're just going to basically tell them you have no say in your interpretation. So, just a couple minutes on Chevron. It was, as I mentioned, 84 Supreme Court case. Chevron v. Natural Resources Defense Council. Chevron established that courts should defer to federal agencies' interpretations of ambiguous laws as long as those interpretations were reasonable. Okay, and this allowed agencies to use their expertise to fill gaps and create necessary rules when Congress passed laws. Okay, so now that's all thrown on its head. And basically, those administrative agencies still can do administrative interpretations, but courts don't need to defer to them. They basically don't need to listen to them if they don't want to. And now they actually have an out and they need to take this out. They can't just punt and say, well, the IRS said this, or the fishing agency said this, or this agency said that. No, we can't take that as the gospel. We have to interpret the rules. And this could lead to a surge in challenges in IRS authority, past rulings, procedures, notices. Not that taxpayers are going to be able to sue the IRS, but there's going to be increased litigation, because now you could take the IRS, or at least not the IRS to court, but you can take a position of the IRS to court and litigate it. And the courts now aren't just going to be able to say, well, based off Chevron, the IRS said this, so we just have to adhere to it and defer to it. No, they can't cite Chevron anymore. So if they think the rule is unfair, unreasonable, not interpreted properly, they can say something, and they have a right to say something. So courts probably aren't going to defer as easily to the IRS expertise, right? Even though the people that work in the IRS are experts, we hope. The courts aren't necessarily just going to be like, you said so, so we're going to listen. It could definitely lead to a longer, more intricate process for issuing new tax rules, right? The IRS is going to have to be even more careful. They're going to be more reserved and limited in the administrative reasoning they provide. But it also can provide some uncertainty for taxpayers, because whatever the IRS puts out as an administrative position, it's not the gospel anymore, right? The courts using Chevron aren't just going to defer to it. It still could be attacked. So I like the ruling personally. I think it's going to be very interesting, because I do think these administrative agencies, I've worked with the IRS for many years. I have friends that work there, great people, but these agencies, they kind of breed their own power, and they like to grow, and they like to have more authority, and the more authority breeds more power. And it's not always, I think, healthy. So I do think courts shouldn't just defer, and they should feel that they have the authority to reinterpret an administrative ruling. And the IRS's broad use of Chevron really started in 2011. There was a case that basically the IRS opened the door for the IRS, and it was called Mayo Foundation for Medical Education and Research, 2011 case. And they basically resolved a split in the lower courts and held that Chevron deference applied to interpretive tax regulations under a specific section. So after that court case, the IRS, basically the Treasury Department, the IRS, they basically took the position that, okay, we have now the authority, and they actually changed the language in their handbook in terms of administrative powers. So it's interesting how this is going to work. The courts are definitely going to have greater ability to apply their interpretations to statute. They're not just going to defer to these agencies like the IRS to say, hey, you're the tax guys, you're the experts. We're just going to listen to everything you're saying. I think this is going to create more litigation. Taxpayers will feel more emboldened to say, hey, we don't agree with this interpretation, IRS. And now that Chevron's gone, we feel like the courts are going to be open-minded and fair, and aren't just going to defer to your interpretation. So we're going to litigate this. Not sue the IRS, but litigate the actual statute or interpretation. So this is good. I think courts should be more active. I think they shouldn't just defer to these administrative agencies. A lot of time the administrative agencies have very reasonable positions, and sometimes they don't. And for courts to just punt and say, well, we don't really want to get into this IRS intricacy or this section of the tax code, maybe we're not the best experts, we're just going to listen to these administrative bodies who are supposed experts, and it seems reasonable, so we'll just adhere to it. Now they're saying, well, we could be a little bit more active, and we're not just going to use Chevron as a shield so we can move on. We're actually going to look at this. So if you look at it, the Treasury Department, IRS, they publish more than 200 regulations and sub-regulatory guidance every fiscal year. Okay, so they're pretty active, and some are controversial. And the controversial ones, taxpayers like you and me, now will have a little bit more, I think, a little more power behind us, a little bit more air to say, hey, this is unfair. And we feel that we actually have a chance to have a court listen to us and reinterpret it, because Chevron's not gone, and they're not just going to defer to Chevron. And the facts are, Chevron was cited 18,000 times by courts. So this was used as a sword and a shield by many courts to basically punt the issue and move on. And now they're not going to be able to do that any longer. So will the IRS still have some power? Yeah. Has their power shrunk? Yes. Has it gone to zero? No. Are they happy with the decision? No. I don't think any administrative body is happy with this decision. They've lost some power, not all of it. They still can do their work, and they can do their administrative interpretations and issue notices and rulings, but the courts don't have to defer to it anymore, which is very important, right? Because they can write whatever they want, but it's not gospel, and the courts could attack it. And before, under Chevron, as long as it was reasonable, the courts would look at each other and say, I don't want to get involved in tackle section, 7265 or some random section. I don't know anything about it. I don't want to get too deep into it. The IRS spoke about it. This is their interpretation. We could just use Chevron and accept it. And now they don't have to. And now they're going to have to, dive deeper and be a little bit more proactive in the process. So I think it's beneficial to you and me as taxpayers. I think it's good for the courts to be a little more active, and it's good for these administrative agencies to understand that you're not elected officials. Okay, people that work there, you may be smart, you may have good intentions, but you're not members of Congress. You're not the president, and there needs to be stronger oversight into your interpretations. It's not the gospel. So that's it. It was an emergency pod. Sorry for the background. I'm not in my office. I was gone for the 4th of July weekend, but I wanted to definitely get this out there. It's a very important case. I certainly suggest people look at it. It's long. It's like a 114-page decision. There's a lot of, if you just Google Loper Bright Enterprises or Chevron case, there'll be tons of really good articles that will pop up that you can read about it. I hope I kind of summarized it. The Chevron case, at least what it stood for in terms of giving administrative bodies deference as long as their interpretations are reasonable. And now the Loper case basically said, no, that's not going to be the moving forward position of the courts. The courts are actually going to be more active and aren't just going to defer to administrative bodies, because who's to say they're experts? They're not elected officials. We interpret, we make the rules. We interpret the law, not these people and not these administrative agencies. So I like the ruling. I didn't think it would ever get overturned, to be honest. This isn't a conservative or liberal opinion. It was, 6-3, wasn't unanimous either way. I certainly think the conservatives are happier with this position, but I think the moderates went with the conservative bloc, right? It's not, there's 9 justices, there's 3 conservative, 3 liberals, and 3 kind of in the middle, and the conservative position, at least overturning Chevron, got some of the more moderates to join their position, which I'm okay with. We'll see. Does this go back to like the Warren Court of the early 80s that was more adventurous? I don't know. But this was a major case, one of the largest rulings, obviously not like a Roe v. Wade type ruling, but because a lot of folks don't kind of engage in a lot of newsworthy items involving administrative rulings and Supreme Court. This is pretty legalese in terms of its impact, but it will impact all of us, and it will certainly reduce the power of the IRS and some other government agencies, which I'm okay with. So definitely suggest you take a look at the ruling. You can read a summary of it and make your own decision, but the IRS is certainly not as happy today as they were a week before, when the Chevron case was still the law of the land. So that's it. I hope you guys had a great 4th of July. Hope your summer's going great. Thanks for tuning in, and I'll talk to everyone again soon. Take care and have a great day.